we good? Sure. Great.
Absolutely.
Thanks everyone for rejoining. We're going to finish our last panel of the day. We have our most in person. We're working our way up to more people in the room. This is a panel for distressed investing issues and cross-border cases. As a reminder for people who are remote that you need to log onto your chat room in order to get your CLE code, and you need your CLE code to get CLE credit. If there are questions that people want to pose, you can do it through the chat room or in the live mics in the room. And to start the panel, I'd like to introduce the panel moderator, Holly Etlin of Alix Partners. Holly is an experienced executive with over 30 years of experience in providing turnaround services for companies in the retail, distribution, consumer products, financial services, media, and hospitality industries in many of the most high-profile and complex cases filed in the country. In 2007, the TMA Association recognized Holly with its Turnaround of the Year Award for the successful turnaround of Winn-Dixie stores. And in 2011, TMA once again recognized Holly with this Transaction of the Year Award for the successful refinancing of Neff Rental. Holly was named Woman of the Year in Restructuring in 2014, and she again won the TMA Turnaround of the Year Award for her work at BCBG Max Area in 2017. So with that, I'll turn the panel over to Holly to introduce everyone else and to begin.
Great, thank you very much. Can everybody hear me okay? We are going to be a partially in-person panel, which I understand is the first for today. So let me introduce my panelists. Immediately to my left is Judge Sontchi from the Delaware Bankruptcy Court. He's been on the bench for 15 years. He's the former chief judge, and he loves cheesesteaks, but only from Delaware.
None of that Philly crap.
Immediately to his left is Frederica Pietrogrande. She's a managing director at Gordon Brothers, based in London office, and is focused on the development of the Gordon Brothers lending and investing strategy in both the UK and Europe. And then virtually our other two panelists, Dennis Dunne, global head of Milbank's Financial Restructuring Group and a member of the firm's executive committee. And last but definitely not least, Rick Morris. Rick is managing director at HPS Investment Partners in their London office, where he focuses on originating and secondary special situations, distressed credit investing in the US and EMEA. Prior to HPS, he held senior positions at Goldman Sachs and then, of course, at Skadden. So welcome, everybody. So our topic is distressed investing. And I'm going to throw the first question out to Dennis. Dennis, what are some of the key recent changes to insolvency law which impact cross-border investing? It's a fairly broad question, but we're all going to weigh in a little bit on that one. So, but Dennis, why don't you start us out?
Yeah, thanks, Holly. That is a pretty broad question. I'll start the answer with a little kind of table setting and discussing recent developments in the European insolvency regimes. But I think at the outset, as a US bankruptcy lawyer, my perspective has always been shaped by looking across the pond at the European insolvency regimes to see whether they can accomplish what a plenary Chapter 11 case can accomplish stateside. And on that score, some of the new regimes are powerful indeed, maybe in some respects too powerful or more powerful than ours, but we'll get into that in a second. And as with any new set of statutes, there's often a great variation between the intent of the legislature when it was enacting the new code and the judicial interpretations that pop up thereafter. But before we get to some of that unintended, maybe they were intended, practical consequences, I'll discuss the changes. Rick will have the honor and the fun of walking us through some of the recent cases out of the chute. But all of this goes back a couple of years. In June of 2019, the EU directed its members to update and modernize their restructuring and insolvency laws. And their directive sought to harmonize restructuring processes across the various EU members. And they thought it would also provide creditors with enhanced roles in the cases and with more meaningful impact on restructuring outcomes. commentators, as these laws were being enacted, have noted that one potential issue arising out of the directive was the freedom given to EU members to adopt restructuring laws that didn't adopt the American absolute priority rule. And we'll talk about, has absolute priority been replaced with something else, some relative priority? Does it matter? Do going concern valuations have a role to play anymore? Can senior creditors be paid more than in full? And what recourse do the junior creditors have in those situations? But with that as the teaser, let me just quickly summarize some of the salient changes that have been adopted in the UK, Netherlands, Germany, France, and other countries. And by the way, they're very different. And I'm going to gloss over the differences. Fortunately, I don't practice there, so the differences are not that meaningful to me. And I was looking for directionally consistent objectives, of which there's a fair amount of similarities, which hopefully will illuminate the conversation for the rest of the hour. In no particular order, I'll take the UK first, in part because there's been some cases that have interpreted this law. So in June of 2020, the Corporate Insolvency and Governance Act became law, created kind of three significant changes to the UK law. There's implementation of a freestanding moratorium, what we'd call a stay. There's a introduction of a new, call it restructuring plan process, featuring cross-class cram down. As an aside, I think I have to define my terms here. I think in the US, cross-class cram down, we refer to simply as cram down. Intra-class cram down is viewed as class acceptance. In the US, it's the majority binding the minority. But they have that concept now, and there's restrictions on the terminations of contracts for goods and services. On the automatic stay part, the new moratorium is less robust than the automatic stay, but can be extended for periods of time. The more interesting part is the restructuring plan. As I said, it provides cram down. It allows a company which has encountered or is likely to encounter financial difficulties to use the restructuring plan process. And dissenting junior creditors can be bound by a plan if at least one class of creditors that is affected by the plan has voted in favor of it, and the dissenting creditors are treated better under the plan than they would be under a quote unquote relative alternative. We're going to come back to what that means throughout today, because the courts appear to have broad discretion to determine the relevant alternative in a given case. And whatever the scope of relevant alternative is, it's clearly not coterminous with nor as protective of junior stakeholder rights as an absolute priority rule. The UK also has a concept of the inability to terminate contracts during this period to protect asset values. Quickly on the other countries, France has also, in September 21, adopted a similar law. The amendment remains untested. It has cross-class cram down, a discretionary stay, but with greater absolute priority protections. I'll go through these quickly so that we can get to the fun part of the event. The Netherlands has also enacted a new Dutch scheme. The debtor remains in possession. You can do these schemes either publicly or privately. There's a moratorium and a stay on creditor action. Long-term contracts may be amended or terminated by the plan, and there's cross-class cram down, but there is a concept of absolute priority baked into the Dutch scheme and going concern value. The case is similar with Germany and in Spain, and we've set out in the materials some of the kind of refined differences between these jurisdictions. But pulling back to set up the next kind of question, it'll be interesting to see how the different courts approach matters relating to valuation. The Dutch scheme, for example, introduces the concept of reorganization value, and that value has to be distributed fairly amongst stakeholders in accordance with their ranking. Both the UK and German regimes look not at reorg value, but at value available in a reasonably likely alternative. That obviously creates some space for different, perhaps surprising, perhaps inequitable outcomes we shall see. And indeed, the UK restructuring plan, I think, was established with the least amount of legislative guidance, at least that I could see, than what we saw in the Netherlands and Germany. and there may be correspondingly more uncertainty on how the courts will interpret and apply that law. But that's my update, Holly, and I don't know whether you want to go to Rick or someone else to talk about what happened after the enactment of that.
Yeah, I mean, I'm happy to, I can unleash a rant on all of these, but I'm happy to maybe touch on the Netherlands briefly as maybe the early test cases yielding results perhaps inconsistent with the legislative intent, and then maybe pivot to sort of put some flesh on the bones with some of the UK developments, because it really is astounding the direction of travel in the UK. Just to touch on the Netherlands briefly, the law on paper looks like a good step towards Chapter 11 like restructuring tools, but with perhaps, as expected, some growing pains. Only the debtor, once the debtor files, it can seek a stay of enforcement for up to 8 months, and only the debtor can submit a restructuring plan. And if a creditor doesn't like the plan, and keep in mind, often these are debtors that are still under the full control of the sponsor, the only recourse a creditor has is to seek to appoint a restructuring expert who's empowered to also submit a plan, but the creditor has no control over the restructuring expert, but has to fund the full cost of the restructuring expert if defensively it seeks to appoint a restructuring expert. So in practice, that's funding almost the full freight of the restructuring to fund an expert who you have no control over, who effectively takes over the proceedings. So as a result, you have a situation where an out-of-the-money sponsor can delay a secured creditor from enforcement for at least 8 months, propose an unworkable plan, force the creditor to appoint a restructuring expert, and force them to fund the administrative freight for 8 months. And that gives the sponsor a fairly large amount of leverage. Currently in the Netherlands, this is being tested, and unfortunately this one hits a little close to home, but by attempting to cram down a secured lender with reinstated debt that's effectively stripped of all covenants with a below market interest rate on the back of a fairly lofty valuation filed by the restructuring expert. So there's no guidance in the law about how that sort of reinstated paper should be valued, consistent with the absolute priority requirements. So the combination of the extended stay of enforcement, the shifting of costs onto the secured creditors, the limited ability to challenge valuation, and the potential devaluation of reinstated debt, all for the benefit of a arguably out-of-the-money sponsor, sort of all combined in a way that suggests that the Netherlands, which historically was perceived as super creditor friendly, and I think that was the intent in this law, to sort of continue to be a balanced jurisdiction. It's not clear that now that the rubber's hitting the road, that it's going to continue to be perceived as a creditor-friendly jurisdiction. But all this is being tested real time. I think shifting, if I can briefly, to the UK, with the new
Rick,
yes.
if I can just jump in, I think you're
Please.
really touching on something that I was going to pose to both you and Frederica, which is, how does all this impact lending structures going forward and lending uncertainty? Because there are a lot of places where you've been pointing out there are real issues for lenders.
Yeah, maybe I'll jump in and use the UK as a sort of an example of some recent precedent, and then some structuring issues that throws off. So, with this new restructuring plan regime in the UK, valuation issues are much more in play than they had been here historically. So I think we're going to see a ton more litigation in the UK than traditionally we have, as sponsors try to take advantage of the new law's flexibility. And there's sort of tension here with the statutory requirement where you now have to determine who's in and out of the money, and as Dennis said, the so-called relevant alternative, with no legislative definition of that. And you have to balance that against the UK court's repeated acknowledgement that they're not really set up for protracted US-style valuation disputes. And keep in mind, challenging creditors aren't entitled to discovery to challenge the company's evidence. So we saw this tension recently in Virgin Active, where it was an incredible decision, but the sponsor was able to exclusively retain its interest in the company with no market testing, while simultaneously using the new cross-class cram-down tool to impair and in some cases zero out unsecured creditors. This was a global gym chain that needed to restructure its UK footprint on the back of COVID. At the time it presented its restructuring plan, London was snapping back. So amazingly, everything was kind of recovering at that moment. But notwithstanding, the company proposed a plan where the secured lenders were reinstated with some slight modifications, but mostly just rode through. The equity sponsors retained their interest. On the other hand, the landlords who claim all their claims were sort of pari were bucketed into 5 different groups. Some were deemed critical and largely unimpaired, but others were marked to liquidation value and suffered a range of impairment, from some impairment to completely being zeroed out. So some of these impaired landlords challenged the restructuring plan. And amazingly, in the decision on the challenge, Justice Snowden made clear that all the challenges related to the violation of absolute priority requirement were largely irrelevant because there is no absolute priority requirement here. All the challenges complaining that the sponsor was able to retain their interest on no valuation and no marketing requirement was irrelevant because none of those requirements exist. And in the context of a restructuring plan, a sponsor can give itself the exclusive right to retain the business. And in the court's commentary, Justice Snowden highlighted that he didn't really want to allow the landlords to develop a valuation challenge and encourage restructuring plans to devolve into what he saw as protracted Chapter 11 style valuation disputes. And amazingly, he criticized the landlords for not coming up with their own valuation. And I say amazingly because he had previously denied the landlords' request for company level information that would allow them to develop their own independent valuation. So you have this, because you're not entitled to discovery here. So there's this total information asymmetry that's embedded in the process, which you'd never see in a Chapter 11 restructuring. And I'm not sure the Parliament here actually understood what an imbalanced regime they were sort of creating by such light touch legislation. It's sort of a big step towards Chapter 11, but not paired with the Chapter 11 protections that you would expect to go with it. So I would argue that this is sort of a recipe for more and more litigation as sponsors take advantage of a statutory regime that overnight went from one of the more creditor-friendly regimes to perhaps the most sponsor-friendly regime in the Western world. So I would expect a fair bit of pushback through both challenges in the UK to try to shape and develop the law, and also recognition challenges in the US when that's required, given this widening disparity between UK outcomes and what you could achieve in a Chapter 11.
So thoughts from the panelists here in the room?
Yeah, so I think that this is a very, very, deep dive into some of the technicalities of both the, reform in the UK and the reform in the Netherlands. But probably looking at Europe and looking at the lending and investing complexity that we are facing when we look at Europe today, we should take a step back for a moment and then go back into the details, because the complexity is generated by the changes introduced into the legal system that are partly due to the EU directive. There was a deadline to implement the directive, 17th of July 2020, extended by most of the countries, something like 17 countries, to next year. There was the possibility given by Article 34B to extend for great difficulties for 1 year time. And then there is the wave of changes introduced gradually over the COVID period to really address the COVID emergency. And some countries like Italy, who had a new law, new insolvency law, actually restructuring law ready, decided to wait to implement the new law because didn't want to add complexity during the emergency of COVID. Or Cyprus suspended to core, the use of the insolvency law. And And I think it makes sense because in a way we were facing incredible circumstances and the normal use of the insolvency law would not work. And then, more changes will come from additional work from the European Commission, both the effort to, get a proposal from a group of experts for the harmonization of the European insolvency law by May 2022, but also the green paper on the non-bank lending. So these are the causes of all these changes, and you very well touch on the two most relevant, probably, changes that have been introduced, UK and the Netherlands. UK was definitely the hub in Europe, and the Netherlands wants to become the new European hub. But of course, Germany, Spain, Austria, and many other countries in France introduce and are about to introduce further changes. What we need to touch on as well is the business framework, because we had a lot of irrational money, a very, very low number of default or enforcement in most of the cases because of this COVID emergency legislation that protected directors, prevented from filing insolvency, prevented from enforcing a default, all these measures that we saw all over the world. But we are also seeing, rise in, raw materials, a total disaster in the supply chain affecting in particular UK. And this entire and complicated framework must also be, as you both touched, connected with the different judicial system and let's say a preference for the lenders to use judicial systems that are reliable in the time and in the predictability of the court enforcement. What I am seeing as a result is a lot of requests and a lot of attention for off-balance sheet transactions. So the European companies got a lot of money, and the European lenders, had to accept the reality, like that the economy was flooded with a lot of very cheap, sometimes free money, and so there's not been much of activity in Europe in general, but there are some specific circumstances that are becoming more and more relevant in this later phase of COVID, like, as I mentioned, the increase on the raw material and the crisis in the supply chain that are requiring some short-term solutions, and solutions that the European banks are not in the position to provide in the time needed, and that really look for a more tailor-made approach. So what I am seeing is the need for off-balance sheet transaction like operational lease agreement or repurchase agreement of inventory, transactions that are really offering a temporary solution to see what will happen in the next 3, 4, 6 months while a longer-term solution can be planned.
So I think a lot of this is over my head, but to give it back to what I know about, which is being a bankruptcy judge, I think there is some real impact on how Chapter 15 might interact with these cases, and I worry, or I would say that there should be a worry by parties that are going through these transactions like the one in the UK and coming to the US for recognition about whether recognition will occur. Generally, we only worry about not recognizing a foreign judgment or decision, mainly based on due process concerns. I think the cases in America, or excuse me, in the U.S., where recognition has not happened, really generally focus on concerns about whether the parties, like the creditors, receive due process. I think that the facts as I understand them in Justice Snowden's case, that's not really an issue. Yes, he had an expedited valuation trial, but he had a trial. I think he said the other day 3 days of witnesses on valuation. Now, I've never known a person or party opposing a valuation to not want more time and more information. And it can take months if you let them have months to go, and they want everything you could possibly want to come up with their own model, et cetera, to do their own valuation. As a judge, as always, you have to weigh the different sides, you have to weigh the exigencies. I understand that there were some very important time exigencies that were driving the timeline in that case. Again, would I agree or not agree, that's up to the judge that actually has the case. And I would not recognize a case because a judge in a foreign jurisdiction weighed issues about timing, but still gave people an opportunity to present their case. That's the kind of discretion I think we should always provide to our colleagues, whether they're in the U.S. or outside the U.S. What we generally don't get into is substance. We generally don't get into, well, I'm not going to recognize this judgment because in that jurisdiction, secured creditors are junior to employee pension claims, which roughly you could say might be the case, for example, in Canada. But we still recognize those judgments. I wonder, however, whether this cross cram-down approach and the ability for the sponsors to stay in control, even if unsecured creditors are receiving very little, if anything, I wonder whether that's going to actually be enforced by U.S. judges in Chapter 15 cases for whatever assets are located in the U.S. It's a fundamentally inconsistent with my understanding of the absolute priority rule. Now, the absolute priority rule only applies in confirmation. We're not confirming the plan. Someone else is confirming the plan, but we're dealing with the results of the transaction in the UK. So I think that's something people who are investing in the securities that are going to drive these cases in the UK, for example, need to understand that they may have some real risks if they then take that decision and try to get it recognized and enforced in the U.S. And I'll probably get disagreed with by all of my bankruptcy judge colleagues.
But while we were preparing this panel, we touched upon the fact that it seems that...
Me?
While we were preparing this panel, we touched about the fact that it seems that more and more U.S. corporations are filing in the UK rather in the US. Of course, there must be a connection with the UK because the scheme of arrangement is a more favorable tool and is also cheaper as a matter of cost of the procedure than asking for recognition
Sure.
in Chapter 15.
Look,
how do you see it?
Management will always take care of management, and the secured creditors will always take care of the secured creditors. It doesn't surprise me that cases would move to a jurisdiction that maybe the sponsors or current equity or management or the secured creditors think are more favorable to that. It doesn't surprise me.
Well, that happens in the U.S. right now,
That's why everybody's in Delaware. Well, not anymore. But that used to be that used to be the reason people came to Delaware. They thought there were advantages to it, or New York, or Texas. So that doesn't surprise me, but that doesn't mean that what happens is necessarily going to be recognized. It's going to depend on the facts and circumstances of the case. I'm just pointing out that it's a risk.
And do you
Judge.
think it might exist, sorry, I'm just curious about this one. Do you think it might exist a good case of foreign shopping?
Well, listen. Listen, I live in Delaware. I practice in Delaware. I am not going to criticize anybody for forum shopping.
Rick, you had something to say?
Oh yeah, I was just curious if maybe put the judge on the ledge here and ask about one case out here that really, I think, bent the limits on recognition, and ultimately it was challenged, but ultimately settled, I believe in part because of some speculation on how the Chapter 15 objection might have played out, but it was sort of resolved ultimately, so we'll never know. But this was Swissport out here, which I thought came pretty close to the edge, and I'm curious if it touched on any sort of yellow flags for you, or if you saw a case like that, what those yellow flags would be. Because in Swissport, it was a COVID-red global passenger and freight handling service business for airlines that was running out of liquidity. It raised bridge financing that was conditioned on implementing a traditional scheme to deliver the company to the secured creditors. It was a 3-month loan, specifically just to create a trigger, to create a relevant alternative of a liquidation. The company used a non-material UK sub, had virtually no assets and 2 employees as the scheme company, and the only company that filed, which assumed the obligations of $2 billion or dollar equivalent of debt to trigger a scheme that was predicated on non-debtor releases of sort of $2 billion of debt against a global footprint of companies. The $1.7 billion of secured debt that traded above par on the back of this plan was equitized. The next layer of debt was junior secured note holders who were zeroed out on the basis of having no value in a counterfactual liquidation. The relevant alternative was determined to be an unstructured global liquidation because the senior secured creditors were given a 3-month bridge with a trigger, and conveniently they said, we'd take 90 points of downside in a liquidation rather than cut a different deal. But effectively, as is now with scheme practice, the senior secured creditors got the full benefit of a going concern reorganization. The junior secured creditors were marked to liquidation value, even though the context was a restructuring. Structurally junior picks at a holdco got 35 cents, and the equity sponsor got a substantial recovery as well, all reflecting the absence of an absolute priority requirement. A subgroup of bondholders sought to challenge the scheme and highlight some of these irregularities. And some of the arguments were that, hey, this is a non-material sub being used to avoid triggering an EOD in the bonds and impose non-debtor releases sort of worldwide for $2 billion of debt. They argued that secured creditors were getting above par and junior creditors in equity were getting recoveries, notwithstanding the bonds were being zeroed out. So absolute priority violations in both directions. The bondholders weren't entitled, and this was incredible living through this one, weren't entitled to see the full valuation reports that were relied on by the company because it was deemed confidential and restricted from the bondholders, even though the company was relying on those reports to zero out the bonds. In fact, I couldn't see our barristers' own submissions. They were redacted because it was deemed confidential. The bondholders weren't entitled to any discovery to challenge the assertion that they would be a zero in the relevant alternative, or even to explore whether the relevant alternative might have been something other than, a value destructive global liquidation. So similar to Virgin Active, the bondholders, they were denied discovery and were relegated to just taking pot shots at the company's submissions. Because the bondholders weren't even included in the scheme on the basis that they had no value in a liquidation, they technically didn't have standing to appear because they weren't a scheme creditor. And therefore, just by appearing and protesting their treatment, they were subject to sanction and cost allocations. And we were getting letters saying, hey, we're up to 2 million sterling, we're up to 3 million sterling. So, most funds aren't set up to bear that type of risk. Finally, as if that wasn't enough, the bondholders challenged in New York the lien release mechanic in the New York governed intercreditor agreement, which the UK process had to preserve, because if you said that the scheme doesn't apply to the junior secured lenders and their rights aren't being impacted by the scheme, then you had to allow them to continue to fight their fight under the intercreditor agreement, which had a contractual absolute priority sort of waterfall embedded in there. The Chapter 15 order, on the other hand, went beyond what you could get in the UK process and enjoined all creditors, not just scheme creditors, from taking any actions inconsistent with the change of control transaction in favor of the senior secured. So effectively deprive the bondholders of their contractual rights under the New York law under creditor, and effectively deprive them of launching a valuation contest in any jurisdiction. Now, had these challenges continued and not been resolved, it would have been interesting to see, if that landed in the U.S. on the back of a Chapter 15 challenge, whether any of that might be a bridge too far, because that's definitely the direction of travel out here.
What do you think? Different classes of creditors being awarded value based upon different valuations? One liquidation, one going concern?
I think, okay.
It's clearly, by the way, Rick's favorite case. He hasn't stated which class of creditors he was in, by the way. But we
I
have
got a
tried
pretty
to
good
find out.
idea
Yeah.
where
Yeah.
Rick stands on both cases.
I will say, in all fairness, like there may or may not have been a settlement. So I know it sounds like it didn't work out well. I actually have no axe to grind here. I'm contractually prevented from saying any more. But
But can I say that? Okay, now we are talking about cross-class crackdown in the US and in the UK, possibly in the Netherlands where it's been introduced. But it exists as a concept in many other jurisdictions and existed for very long. What is, I think, fascinating is that overall the discussion is always on the same points, like the class should be homogeneous in terms of the legal requirements, in terms of the business, in terms of how it's treated in the plan. You have the essential, non-essential creditors. They are always the same topic. And there is, I think, a consistency in how the courts internationally are treating the topic. I know very, very well how it's treated in Italy, because before joining Gordon Brothers, I've been practicing law for 15 years. In Italy was introduced in insolvent composition with creditors, I think it was around 2005, and further introduced in pre-insolvent composition with creditors for a very long time. Personally, I have an idea of what should be, the outcome, but I am not a judge, and I will never be. So my opinion probably doesn't matter a lot for this purpose. But here again, the court system and the predictability of the outcome of a court decision is crucial. Like investors and lenders who might look at an investment as an exit strategy in case of default, are not testing and are not willing to test a new law. For example, in the Netherlands, like we only had 4 public decisions we learned this morning. The law has been, effective and implemented 10 months ago. We had about 40 cases, only 4 effective published decisions. And, investors and lenders will wait to see how it will be implemented. And these are crucial points, because if you're a secure lender, you want to know how you will be treated and what are your chances, for example, to propose a plan or not to propose a plan because you are not allowed by the specific regime.
Well, I may be dating myself, but Dennis will remember. Remember Thailand? Who in the room
Absolutely.
remembers Thailand? Where lenders thought they had a security interest when they were lending there and discovered that they didn't. That's about 20 years ago now, but really caused quite an issue for a period of time, and then it got resolved through, ongoing modifications to the local law. But Frederica, given all of those issues, how are you structuring deals then at this point in time? I mean, Rick, you too, how are you guys structuring deals, given that things may not go well and you may end up in these situations?
Go first.
Okay. Well, let me wear my sort of rescue lender, super senior lender sort of hat here, because this is a real challenge, particularly in the UK. As a frequent kind of super senior rescue loan investor, all this uncertainty around the new RP regime here, really creates issues for super senior debt. We were talking before about what happens when all these government emergency measures, and eventually they're going to have to recede, and someone's going to have to step in to fill the breach. And lending into stress sort of situations in the face of this uncertainty is going to be, really difficult. As I said before, these new cross-class cram-down tools, if there's a theme here, it's that these jurisdictions are bridging closer to Chapter 11, which is great. But if you don't pair it with the finely balanced sort of substantive protections that go with it, you're almost better off not having it, because they're just subject to abuse. I have no doubt that over time, through precedent, there'll be a balance, but it's not there today. So if you think about, in the UK and some other jurisdictions on the back of the EU directive, the only guardrail, the only defense you have from being crammed down or crammed up is best interest tests. Are you clearing liquidation? And that's in both the scheme context and the RP context. Favored creditors get reorg value, disfavored creditors get marked to liquidation value, even though the context is a going concern. So in theory, I can provide a well-covered super senior rescue loan to a stressed borrower and be subject to impairment, term out, covenant stripping, and a restructuring plan that's supported by junior creditors, as long as I would be impaired in a hypothetical liquidation, even though if there's never going to be a liquidation. That's the only guardrail. So this is particularly problematic if you think it through. We've looked at some asset-light businesses that would never liquidate because everyone would take a bath, but that's what I can get marked to, right? So the problem for super senior lenders, how do I price super senior debt in the UK or some of these jurisdictions with these new laws if I'm subject to that type of impairment? All for the benefit of junior constituents, right? That doesn't feel like super senior debt that I would price at 7 or 8% when I'm subject to a regime like that. And I probably can't price it as super senior debt anymore unless there's some structural mitigants, which I don't know, a bad boy guarantee from the sponsor, maybe fund into an SPV that won't allow any other creditors. And maybe this is less of an issue if it's an asset-heavy business and I'd be par in a liquidation. So I could argue, hey, in the relevant alternative, do your worst. I would get 100 cents cash on the barrel. But eventually this will have to be sorted out. But as we said, the legislation is incredibly light on detail. So it's all left to the courts to work this out over the next several years. But in the meantime, uncertainty reigns, and it's kind of a sponsor's paradise and a structuring nightmare, right?
By the way,
because
Rick,
there's not
on that part, I think that the Judge Stoughton opinion came out about a year ago. And over the last year, I've had more conversations with sponsors and equity owners about how can we get into the UK and do a full RP process than I did before. And picking up on somebody else's point, it had less to do with the enactment of the statute than how Judge Snowden dealt with objections that would have gotten traction over here. This violates the absolute priority rule. Well, that's good, but we don't have the absolute priority rule. Well, you have an insider violating basically the LaSalle requirement to have a market test for the equity they're retaining or purchasing back. Well, we don't have that either. And as a result of that, people are trying to go to the UK, and they don't. My understanding is that they're not requiring COMI for the commencement of a restructuring plan process in the UK. They have a concept, which again is going to be subject to courts setting the limits of sufficiency of connection. So clearly they're contemplating companies can avail themselves of the restructuring plan process as Judge Snowden has interpreted it, with something less than a COMI basis for doing so. And that has been, a lot of companies with existing capital stacks are trying to figure out how to leverage that. Even if the leverage is, as you were saying, just in the negotiating room, in the conference room with creditors, just the specter of potentially doing that has real value.
And the UK is the easiest and most favorable legal framework you have in Europe. So imagine that if the recent changes in the UK market are creating so much discussion and talking. Think about all the opportunities, lending and investing opportunities in Europe, where the changes are not supported by a judicial system which is so proactive and so, let's say, so reliable in the service and the decisions that can provide in the interpretation of the new law. So honestly, when we look at Europe, we look on each single opportunity is different and each single country is different. But what I think is interesting to share with you all is what we look at in relation to any opportunity. What are the questions we look at? And the first one that is never discussed is the regulatory framework. Because in Europe, there is a very strict regulatory framework for lending if you are not a bank or a regulated financial institution passported in the specific country where you intend to do business. And just to give you an example, in Germany, you cannot offer, lending or financing services to the public, and I mean corporate, of course, not consumer, if you are not regulated. In France and in Italy, there is a strict restriction, like in Portugal, in Austria, in Norway, for example. In other countries, the restriction is softer, so there are a number of activities that are not regulated and number of activities which are regulated. It can be a distinction between consumer, corporate, mortgage, sale and leaseback, yes or no. And in some other countries, like France and Italy, where the activity is of lending and investing is regulated, then you can use securitization structures, which have been deregulated and extensively used in the recent years. So this is the first thing you look at, because of course that will determine what is your strategy of lending or investing, whatever is the opportunity you're looking at. And then you start looking at, the enforcement. Does the enforcement work? How long does it take? It is reliable. And then you look at, if I am a creditor, can I file for a proposal? Can I put forward my restructuring plan? Many countries, you would be surprised, you cannot. And then, okay, can I credit bid? In case of insolvency, what are the clawback action rules? And all of this is country-specific. So what is the main obstacle? What are the main obstacles? Definitely the first big one is the regulatory framework. That is not here the right question and the right panel, but if you think about that, is as a big impact in terms of competition. You might have the very same company that in one country can get financing and in another country can struggle to get financing, if not from the banking system. And I have no problem with the banking system. It's just that in some countries it takes too long. And in some countries, if you're a secure creditor, you can file your plan. In some others, you cannot. And when I mean file your plan, I mean without the required cooperation of the debtor. But what I think that we are monitoring in Europe is we are monitoring disruption. And disruption, for example, comes from the ESG regulation. So most of the European banks are limiting their exposure to fossil fuels and many other industries. We are looking, as I mentioned before, at off-balance sheet transaction, but we are also looking at disruption in relation to the implementation of new piece of legislation. For example, there is a new legislation that should be implemented in Italy, which is a new pledge over movable assets that allows an out-of-court enforcement through basically the implementation of an electronic registry held by the Italian tax authority. So it should be a private deed and over movable assets that in case of default allows the creditor to have an out-of-court enforcement and repossession with the transfer of the title, which is kept within the electronic registry created by the Italian tax authority. Of course, this would, give me a second. Of course, this would have a tremendous impact because in most of the European countries, you cannot have an effective ABL strategy because enforcement doesn't work. And a tool like this one could open the ABL market. A very similar tool has been implemented in Belgium, for example, in 2018, and is working very well. So, overall, I think that when you look at Europe, you look at each single specific country, you monitor the legislation, the regulatory, not only the insolvency law, and I would say only partially the insolvency law. You look at the regulatory framework, you look at the banking legislation, you look at the insolvency legislation, you look at the court implementation of the current legislation, you look at what are the laws that are to be implemented in the short term. And this is the assessment you need to make. And sometimes the insolvency law doesn't put the required attention, or the legislator doesn't put the required attention on some aspects that are, for example, how long it takes to have a restructuring plan approved. One of the reasons why I like the Dutch scheme is that they have a very tight time schedule. Of course, it's not mandatory and can be extended up to 8 months, but still, the intention is to give clarity on the steps. 8 days after one event, another one occur. And the second one is also that it's true that, for example, in the Dutch system, the creditor, the third party, doesn't have the right to file a proposal, but it's also true that you can have appointed a supervisor which will look at the documents and the preparation of the plan in the best interest of the secured creditors or a specific creditor, which I think is a step forward. And all of these is all interconnected, really. So when you go back to the UK and you think that, okay, it was a very, very creditor-friendly country that decided to introduce as a form of transplant some debtor-friendly measures, but is still incredibly friendly. And the scheme now is a very powerful and flexible tool where you can include all sorts of economic proposals.
It's funny, I did several panels and attended several panels early in COVID about how the London insolvency practice was dead because of Brexit. And now 6 months later, everybody's going to London after 1 or 2 decisions out of some amazingly good judges. So maybe that teaches me that we can talk a lot about how to handle investing, but we live in such a fluid economy. We live in such a fluid and dynamic legal economy with the changing of laws that I think it's probably very challenging for investors, because who knows what's going to happen a year from now or 2 years from now in connection with the law. And there seems to be some competition. When I was in law school, they called it the race to the bottom, but we don't say that anymore. But there seems to be some real competition among jurisdictions to attract cases, and it's going to be interesting for me to see how that develops. And then as a judge who has to decide that may happen in the U.S. as well, but as a judge that has to decide, what to recognize, I think it's going to might be challenging to figure out whether those new regimes and schemes are sufficiently consistent with our concept of justice in the U.S. to merit recognition.
And maybe to be responsive to Holly's question about, well, what does an investor do with all that and all that uncertainty? When I think about these things, and it's obviously very jurisdiction specific, you're still thinking out here, and this is definitely not the thought process in the States, but, you know, can I get a single point of enforcement in a more efficient jurisdiction, like interposing a double Luxco, and then assessing the tax issues that creates and whether I have leverage with the sponsor to even request that. In France and Spain, we've seen fiduciaries, which are trust structures that are set up to hold equity and trust to take the equity interest from the operating companies out of the estate in the event of a filing to facilitate an out-of-court enforcement. It's often hard to get a sponsor to give that up in the negotiations in a performing deal, but for a stressed deal, that's possible. And it's these structures in France and Spain haven't really been tested yet, but lawyers think they work. Sometimes, you know, we'll in some racy jurisdictions, we've transferred assets to an SPV to ring fence them from the broader stress in the group and try to do it in a way that minimizes clawback issues if the broader group fails. In some jurisdictions, we've used voting arrangements like a golden share. So even though the process can be used hostilely to block our enforcement, if we can replace the management, because these are, in Europe, you have a lot of pre-insolvency sort of procedures where there's a moratorium associated with it, but it's not technically a bankruptcy. But if that's being used to stymie us and we have a golden share, we can vote to replace management, even though we can enforce and at least withdraw the proceeding and then have a negotiation on a more level playing field. And if I can't structure around the jurisdiction, can I lend into that jurisdiction with a very broad intercreditor so I can bind junior creditors in the equity not to support a non-consensual plan? So ultimately, it's very jurisdiction specific, and it gets very complicated very quickly when there's assets spread across multiple jurisdictions. But you know, some of these are techniques to try to mitigate some of that uncertainty.
Dale, I think, Rick, you've got probably the key point, which everybody has been referring to, which is that there are very few large-scale restructurings that are either in a single venue or are financed via debt predicated of the laws of a single entity, you know, a single legal jurisdiction. So, you know, we're inevitably going to get a lot of creditor clashing, and with these law changes, a lot of people, I think, pulling a lot more aggressively to try to pull it into the venue that is, you know, going to be more favorable for their interests. So, and of course, you know, I'm always sitting with management, and I'm sitting there wondering what in heaven's name we're going to do because everybody's grabbed a leg or an arm and is, you know, going to make a wish. And there we go. So we have a few minutes left for questions. If there are any, either online or in the room, we're happy to take them. If anybody wants to know what people think about where we're going here, there's certainly a lot of irrational money out there, so I think deals are going to still get done, and people are going to kind of hold their nose because they've got to put money to work, or they're going to have to give it back to their investors. So, you know, we're just going to kind of plunge forward, but it's going to make for some, I think, really, really interesting restructurings in the future. Any questions at all? Any final thoughts? Judge, start with you. Any final thoughts?
No, you know, I learned 25 years ago when he was kicking my butt in a case to always listen to Dennis, so I'm going to defer to Dennis.
Well, there you go, Dennis. Now you're.
By the way, I lost in that case that he's referring to, but yes, no, because I was going to echo what Judge Sontchi said before, is that when the legislation was enacted in the UK, I kind of looked at it with interest, but I saw you can go around the globe and look at so many regimes that have similar scaffolding out there. It's really a question of what the judges do with it. And that was the event. And we have one case out there. It's going to be fluid and it's going to change. And there's a little bit of, you know, to superimpose, American mythology. It's a little bit of the Wild West out in Europe right now, but it'll be fascinating time for lawyers.
Frederica, thoughts?
I think it will be an interesting 2022 because, you know, tax holiday, rental holiday, you know,
it's all going to come due someday.
Yeah, but even if you are not technically a zombie, so you should not have filed for insolvency already, there will be a lot of that restructuring ahead. And I think that all these new regimes and the new legislation implemented in each single country in Europe will create an additional layer of complexity. So we need to have more courageous and courageous, it means you see the risk and you assess the risk and you take a conscious risk out there, because I feel that outside of the UK, investors and lenders are concerned, at least.
Okay, Rick, you got the last word.
I think I agree with Dennis. Great for lawyers, terrifying for investors. This direction of travel.
There we go.
Well, that's a good day.
All right, well, thanks to all of you. Thanks for all the work. Thanks for, Rick, thanks for dialing in so late. I know you're in London, so thank you for joining us. And I think we're done, 20 seconds early. Thank you all.
Thank you very much.
Thank you.
Thank you.
Well done.